President, please be seated. The court is now in session. Today, the chamber will continue hearing the testimony of Kang Gi-il alias Duy. Greffier, Ms. Jia Si-Huang, please report the attendance of the parties and other individuals at today's proceedings. Greffier, Mr. President, for today's proceedings, all parties to this case are present, except Mary Giro, the international co-lead lawyer for civil parties, is absent without reasons. Mr. Nguyen Chia is present in the holding cell downstairs. He has waived his right to be present in the courtroom. The waiver has been delivered to the greffier. The witness who is to testify today, Kang Gi-il alias, is already available in this courtroom. President, thank you, Ms. Jia Si-Huang. The chamber now decides on the request by Nguyen Chia. The chamber has received a waiver from Nguyen Chia dated 21st of June 2016, which states that due to his health, headache, back pain, he cannot sit or concentrate for long, and in order to effectively participate in future hearings, he requests to waive his rights to participate in and be present at the 21st of June 2016 hearing. Having seen the medical report of Nguyen Chia by the duty doctor for the accused at the ECCC dated 21st of June 2016, who notes that Nguyen Chia has chronic back pain when he sits for long, and recommends that the chamber grant him his request so that he can follow the proceedings remotely from the holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, the chamber grants Nguyen Chia's request to follow today's proceedings remotely from the holding cell downstairs via audio-visual means. AV unit personnel are instructed to link the proceedings to the room downstairs so that Nguyen Chia can follow the proceedings. This applies to the whole day. Next, the chamber gives the floor to the defense team for Mr. Nguyen Chia to put questions to the witness. You may proceed.
Thank you, Mr. President, and good morning. Your Honors, good morning, Counsel. Good morning, Mr. Witness. Yesterday, when we broke, we were speaking about surveillance and monitoring people who were suspected. We also spoke about people who were implicated by confessions. Let me follow up on that by asking you a question as to what you meant when you gave evidence a few days ago, the 13th of June 2016 at 11:10. You said, and I quote you, "In terms of implementation, I was repeatedly instructed and warned not to make any arbitrary arrest of anyone." What exactly did you mean when you said that?
Witness, thank you. Mr. President, this is not my word. That is the lines, party lines, and also the political line of the party. The arrests which were not endorsed by the party were illegal, and the one who made the arrest would be responsible. I made mention about Sok Kuchumran from Sector 25. He killed a party member. After 17 April, Sok Kuchumran was arrested and smashed. Another real example, it was the case of Nat. He made the arrest of people at Dak Mau concerning the vehicle reversing, and the individual Hiep Kok was arrested. Nat and I were working together in 1966. We were in the branch of the party, and I knew at the time that Nat made the arrest illegally. I talked to him that any arrest were not endorsed by the party would be considered illegal, and we would be considered traitors. As a result, we would be in danger. When Brother Sun Sen, our superior, called us to work with him, Nat at the time pretended to be proud, and at the time Brother Sun Sen took off his glasses and made mention about illegal arrest. So what I have told you is concerning the party line. It's not my word. I was a party member. I had to adhere to the party lines, and I did not make any arbitrary arrest, and my subordinates would not be allowed to make arbitrary arrest as well.
Yesterday, we spoke about the arrest of Yin Sambat, the one who threw the grenades behind the royal palace, and the arrest of Chan Chakrai. What you just said, does that mean that Yin Sambat and Chan Chakrai were not arbitrarily arrested?
President, please hold on. Mr. Witness, you may proceed. International Deputy Co-Prosecutor.
I think in the interest of clarity, counsel should be clear in his question. Arbitrary arrest has one legal meaning. As we've just heard from the witness, it has a very different meaning for this witness, which is that the arrest had to be approved by the party. So I think counsel should be clear. Is he asking him, were these arrests approved by the party?
Well, the witness is not a lawyer, Mr. President, so I'm using that exact same word. I think this is the way I should be asking the question. Following literally his words, were the arrests of Chakrai and Yin Sambat arbitrarily? So I'm just using his own words. I know there's a legal meaning to it, but still, I think I should be able to ask that question.
Why is it so difficult to rephrase if there is no second thought behind it, to clarify it?
Fine. Mr. Witness, was there a good reason for the arrests of Yin Sambat and Chakrai?
Mr. President, since I have come to testify this court, I have repeatedly made mention of the matter raised by counsel. Santiba did not have the authority to decide on the arrest from the time when I was M13 up to the time I was chief of S21. I was first chief of M13 and later I became the deputy and head of S21. I myself never issued any decisions to make any arrest. The arrest of party member was to be decided by the center. Warned and trusted me to the task to be chief of M13, and he warned me about the arrest not to be made without the decision of the center. M13 was required to receive the arrested people only. However, sometimes they ordered M13 to gather the forces to make the arrests. So in summary, the arrests of Yem Sambat and Janjakray were decided by the upper echelon, and then the two individuals were sent to S21 after the decision for the arrest, and after the individuals were arrested, they were sent to S21. So again, decision of the arrest were made by them, and they were sent by the superior above as well. I do not understand about the international law. However, according to the party line, no arbitrary arrests could be made. So Santiba went to make the arrest based on the endorsement of the upper echelon. So in accordance with the lines or party lines, the arrests would only be made after the decision or endorsement of the upper echelon. In my life, I never issued any decisions for the arrest without the endorsement from the upper echelon.
Please listen to my question, Mr. Witness, and don't repeat yourself 100 times. Do you know whether the party center had a good reason to arrest Yin Sambat and Chakrai? Was there a reason, suspicion of treason, for instance, for their arrest, or involvement of sabotage, or involvement of planning of a coup d'etat? Was there an actual good reason for Yin Sambat or Chakrai to be arrested?
Thank you, Counsel. It's beyond my knowledge to respond to your question. A few days ago, I made a mention about Aubry Abaja, a French person. He said the political regime ended, the government also ended, but the police will be in operation. So the investigation is dependent on the police. However, the decisions are made by the government. One time I met Victor Lebret. Do you know that guy? Victor Lebret was the High Commissioner of Human Rights. Is a High Commissioner of Human Rights. The individual went to see me in the detention cell, and he said police officers has to adhere to the decision of the government. So governments makes the decision, and the police will have to adhere to the decision by the government. So the question put by you cannot be answered by me, since it's beyond my understanding, and I cannot answer it. Only the people in the center could do so.
But Mr. Witness, you were involved in the interrogation of Yin Sambat. You were involved in the interrogation of Chan Chakrai. Yesterday we discussed that Chan Chakrai was monitored for a long time. At least you should be able to answer the question, what had Chan Chakrai done that led to his arrest?
Thank you, said the witness. President, please hold on, Mr. Witness. You may proceed, co-prosecutor.
Yes, Mr. President, counsel's asked the same question 3 times now. He seems to be encouraging the witness to speculate. I think the question should be very clear that he's asking for the witness's knowledge, if he was informed, and other than from confessions, for the reason for Chakrai's arrest, and is not being asked to speculate.
I think it's a perfectly appropriate question. I just try to use very simple terms. That's what this witness seems to understand. I know I've asked the same question in other words before, but asking him in simple words, does he remember what it was that Chan Chakrai had done that led to his arrest, I think is a completely appropriate question.
President, the witness is allowed to answer the question and you are instructed to respond to the limit of your knowledge in relation to the arrest. Witness, thank you, Mr. President. I made a clarification already about the reports of S21. The reports from S21 served as an element for the basis of the upper echelon decisions. The decisions by the upper echelon were based on their own reasons. S21 arrested anyone based on the reports of S21 without the authority permission from the upper echelon would be endangered. So arrest made by S21 was to be endorsed by the party or the center, and the government, as I said, makes the decision, and the decision would be adhered by the police officers.
It seems you're not capable, Mr. Witness, of answering that question. Let me move to Koi Toon. What was the reason for Koi Toon's arrest?
I have a limited knowledge of Koi Toon's case. When I lived with Koi Toon at Bang Thom after 29 October, I observed that Koi Toon was a gentleman, and later on Koi Toon was notorious for having affairs with women. that was the rumor at the first stage, and I was not learned about it initially. Koi Thuon had the affairs with a woman in Phnom Penh, and after that affairs was learned by the spouse, Koi Thuon ordered the arrest of Long, and when Long was being arrested, Koi Thuon was there as well to help the arrest and put him in a bag. So in the case of Koi Thuon, I have known him much, but I do not have the full knowledge concerning Koi Thuon's case. So I have known only 1% of Koi Thuon's case, and as for the reasons of the arrest, of Koi Thuon's arrest, I do not know. So the affairs of the country at the time was in the hand of 870, and I knew only a minimal part of the affairs, President. Duc, now to deal with the issue, if you do not know the answer, please say so. So answers what you can answer what you can, and if you do not know, please say so, and you cannot respond to the question on behalf of the Angalo or upper echelon.
So you don't know anything about the reason of the arrest. Do you know anything about the way Koi Thuon was arrested? Where he was arrested? How long it took to arrest him? By whom he was arrested? Do you know anything about that?
Mr. President, Koi Thuon arrests. In fact, Koi Thuon brought Koi Thuon in, and I only received Koi Thuon. So Pang brought Koi Thuon in under the instruction of the center, and the Koi Thuon was brought into S21 was under the instruction of the center as well. Brother Son Sen was the former chief of 870. He said Koi Thuon was once my superior, so I had to be careful. So the instructions from the center were clear, and S21 was at the time waiting to receive Koi Thuon.
Did you know how Koi Thuon ended in the power of Pang? Did you know what happened before Pang transferred Koi Thuon to you?
Koi Thuon was removed from party membership in April. I cannot recall the date, and he was detained at the center. So after he was removed, Koi Thuon had no authority over Pang, and Pang instead had the authority over Koi Thuon after he was removed from the membership and was detained at the center. So after the person was removed from being member of the center, the position was also removed from being the Minister of Commerce. So before, Koi Thuon was detained was under house arrest, he had authority over his subordinates. And as for Bong, the Office 870 had authority over him. After Koi Tun's arrest, I had authority over Koi Tun, and I had to convince Koi Tun to write the confessions for Angka.
Mr. Witness, have you ever heard of a combatant of the 704th Special Forces Battalion, Meng Hak?
Mr. President, it's a bit strange for me after hearing the question. I cannot recall the 704.
Well, let me read to you something, Mr. Witness. Maybe you heard of it, but I doubt it. Mr. President, I will be referring to E3/2117, English page ERN 000813444, Khmer 0019295. There's no French translation. This is what it says. Meng Hak, a veteran of the 704th Special Forces Battalion, was assigned to arrest Koi Tun, Secretary of the North Zone, who was residing north of Wat Phnom. It took 2 days and a night before it was possible to arrest Koi because of the many soldiers guarding him. End of quote. Is that something that you heard at the time, that it was very difficult to arrest Koi Tun?
Thank you, Counsel. Mr. President, I do not really understand after hearing the quote, and I do not know Meng Hak either. And as for the difficulty in arresting Koi Tun because he had many soldiers, that is not true. It was not difficult at all to arrest Koi Tun. This is what I can clarify.
Let me move on to the next point in regards Koi Tun. Yesterday and other days we discussed the fact that S21 or the Regiment 21 was a military regiment subordinate to the General Staff, and I quoted you as saying that you were a military person. Now, in one of your statements, E3/65, English ERN 0014751 and Khmer 00146480, you talked about receiving orders not to torture Koi Tun, but you added a word. You didn't say you received orders, you said you received absolute orders not to torture. Is there a difference between receiving orders from your military superior and absolute orders?
S21 had to adhere to the principles set by the party. Torture shall be conducted in case of necessary. That was taught by me in relation to interrogation methods, and Pupali recorded the content of the study session. And the instruction from the above to me was to require me to interrogate Koi Chun by myself. And as for the methods of interrogation, of Koi Chun's interrogation, I made a mention several times. And the instructions in relation to Koi Chun after he was arrested were that I had to be careful since I was his subordinate, and I was warned not to be convinced psychologically by Koi Chun, and I had to be strong in my stance.
But I'm asking you as a military person or as a person part of the military hierarchy, is there a difference between receiving an order and receiving an absolute order?
Khmer words, because I'm not sure he really gets the gist of your question. Compare the two Khmer terms.
Well, I know what I wrote down from the English transcript, but I'm happy to ask.
I'm not saying you are doing something wrong. I just suggest if you confront him with the two Khmer terms he used, it might be easier to ask him if there is a difference.
1 second, please. The National Council for the Kyusupan team said that there was an accurate translation in Khmer between orders and absolute orders. So apparently in Khmer it came across. But let me, in any case, double check the original Khmer transcript. Would the co-counsel for the case in front of me so kind to read those two words?
Mr. President, let me read. I will read from the text. Quote the related phrase. During the interrogation of Koi Chun, I was ordered absolutely not to use torture, and that I should interrogate him by myself. End of quote.
So again, Mr. Witness, you seem to add an extra word to being ordered. You were absolutely ordered. And my question is, does that mean something even stronger?
Witness. Thank you, counsel. I hope that the word which has been read, it was quoted from my statement to the co-investigating judge. Thank you, Mr. Counsel, and I saw you nodding. So the words indicating my view during the investigation stage in which I respond to the co-investigating judge. Talking about the interrogation of Koi Tun, it was monitored every day by Son Sen, and he kept following the confession. It was an absolute order, no one there to touch. So Koi Tun was taken there and put and allow him to sit on a bed, and when he was very angry and he broke the eyeglasses and threw away the pen, and I assigned 2 guards from the special unit to guard, and I ordered them not to inflict any torture and prevent him from committing suicide. So it was an absolute order not to commit torture or not to cause any problem against him. So it was not intended to inflict any torture until it is the last resort. So in his case, Koi Tun fall in this category.
In order to understand exactly how the interrogation of Koi Tun went, let me take a sidestep and try to see if I can somehow compare it. In your own trial, you were accused of using violence during an interrogation of a person called Chit Iv. And you acknowledged that you intervened in the interrogation of Chit Iv. In your testimony on the 16th of June 2009, E3/5800, you said, and I quote, "So I only slapped into the face of Chit Iv because I knew that he gave in to me, into my interrogation already, that I could not beat him much." And as you recall, in your case, the trial chamber acquitted you of torture charges in relation to Chit Iv because the trial chamber ruled that the slapping did not cause enough pain or suffering of the severity required for a finding of torture or other inhumane act. Now, comparing the interrogation of Koi Tun and Chit Iv, is it correct to say that a certain amount of violence was used in respect of Chit Iv, but none whatsoever in respect of Koi Tun?
Witness. Thank you, Counsel. Mr. President, it was my testimony during my case, in particular to the co-investigating judge. I was the deputy chief of S21 when I was slapping Chit Iv, and Ma Meng Kieng Elias Mon was the one who interrogated Chit Iv, and Chit Il was very angry and during the interrogation, and Nat was about to beat the victim, and I was there and I slapped Chit Il during that session because I have better experience and I collect more documents related to Chit Il, so I did that. It is the truth. When it comes to Koi Thun, in the court proceeding, in one section of my testimony, there was an effort to connect me to the torture against Koi Thun, but it was an absolute order not to torture Koi Thun. So you cannot compare Chit Il case to Koi Thun. So in Chit Il's case, I use certain words and then I slapped him. But for Koi Thun, I use a kind of psychological pressure on him for interrogation.
I will come back to the general use of certain interrogation methods later. Let me finish my questions about Koi Thun. In your WRI E3/1570, English ERN 00154 Khmer 00154224, you said that Son Sen sent Koi Thun to be executed. My question to you is, what were the reasons Koi Thun were executed? What had he done? Had he committed treason? Had he planned a coup d'etat? Had he staged a rebellion? What was the reason that Koi Thun was ultimately executed?
Witness, thank you, counsel. It was decided by Office 870 to arrest him, and the interrogation of Koi Thun was done in pursuant to 870 order. Son Sen, who was following the case very strictly, and Koi Thun was kept for a while, and later it was decided by Office 870 to smash, to kill him. Regarding the reason for his execution, so the policy of the CPK during the 70s, so any enemy of the party shall be smashed. So anyone who was arrested and sent to the security center was an enemy. So at S21, there are 12,000 plus victims who were smashed. They were decided by the party and considered enemies, so they were all smashed, except one victim who was spared to spare for life.
Mr. Witness, I'm not so interested in you repeating the general principles. I'm asking you about one case only. You already said that you have no idea why he was arrested, but at least you should be able to tell us what the actual reason was that at one point in time he was executed.
Witness. Thank you, Counsel. Mr. President, I repeated many times, so anyone who was arrested must be smashed. So I don't know the reason behind the execution. So the reason during the DK regime was simply anyone who considered as enemy was to be smashed. Before execution, the person would be sent to the security office for interrogation and then smashed. President, thank you. The response appeared to be sufficient for this purpose.
Yes, I will move on, Mr. President, to my next subject, but I will return to Koitun and Un and others later. Mr. Witness, you've answered many questions already in relation to interrogation methods that were used by you and Hoare. When you were questioned by the prosecution, I didn't object to that, but I will confront you with the use of the word, the use of the Khmer word for torture. Now, it's my understanding that in all contemporaneous documents and also in all your testimony, you use the Khmer word Teyaruna Kam. Is that correct?
Witness. Thank you, Counsel. The Khmer word Tirunakam was used since I was in M13 through to the 6th of January 1979.
We discussed this word Teyarunakam in a hearing a few months ago, 27th of April 2016. And at one point in time, the President intervened in a discussion, or the legal discussion of that word. And I would like to read to you what the President said about this word, and then I would like to ask your reaction to that word. So, Mr. President, I'm quoting you. At 14:05, the 27th of April 2016, President, counsels, you should limit yourself to other terms, probably like inhuman and degrading treatment, because the word Teyarunakam in Khmer or generic torture definition is really common in the Khmer context. For example, when a father disciplines a child, we also use the same word Teyarunakam, and that could not be legally defined as torture. So the word has been invited within the behavior and tradition and culture of Cambodia. End of quote. Can you react, Mr. Witness, to the words of the presiding judge?
Witness. Thank you, Counsel. Mr. President, I do not recall your statement. So when I listen to the quotes, it reflects the practice in Khmer family practice. It is part of culture in Cambodia, Cambodian family.
So, trying to be a bit more legal, in the hope you will understand, Mr. Witness. Does the word Tearunakam mean both certain forms of violence, being human or degrading treatment, and ultimately also what we call torture?
Sorry, Counsel. I mean, as you yourself said, he's not a lawyer. Inhuman and degrading treatment, I know the President introduced it, but it's a legal term too, as we all know. Torture is a legal term. And you are asking him to clarify if a certain Khmer word is identical to any of those two. I think this is beyond to what a witness can do.
President, my intention in that occasion, because the parties object to witnesses when discussing on torture during the examination. So I was trying to avoid any controversial during the proceeding or examination, because it was often objected during the questioning. So I was thinking of two things, because I think it was not legally defined when it used in the ordinary Cambodian family, but later I used another term. I advise the lead co-lawyers for using the correct term. I advised that she would use mistreat rather than torture. But mistreat is less legally in meaning than torture. It was my advice for the lead co-lawyer, and based on the testimony of the witness, based on his knowledge during his experience in doing his work. So in this proceeding, you should use the proper term to avoid any controversial and any objection if it lead to be objectionable. So we expect to hear from the witness the term that is used at S21. So you should not confront the witness with the legal terminology. So you should rephrase your question in this context.
I think I've said it at an earlier stage. Perhaps it's easier to be more descriptive, asking him if he uses the word, what kind of actions does that involve, as opposed to trying to compare it to legal terms.
Yes, let me try to do it very factual. Mr. Witness, when I read to you that excerpt from the President's intervention, you agreed. Could you tell me what kinds of behavior Tearunakam could occur in a ordinary Khmer family in your time?
Witness. Thank you, Counsel, Mr. President, Your Honors, and fellow Cambodians. My mother used to hit me when I commit any mistake, and my father also blamed me and saw his face expression as a threat. I call those practice as tyrannicum, as torture, because it was a discipline against any violation of the family discipline. During the CPK regime, I used the term to implement the disciplinary rule. So when one of the enemy fled from the security office, I implore Sun Sen to punish me because I made a wrongdoing. I told him that he can remove me from the party membership. So in practice at M13 or at S21, it referred to the inflicting of acts against the physical, the body of the victim to inflict pain. So I instructed my subordinate that we should push the enemy to the corner, and then we can torture. In ordinary Cambodian family, when a mother hit a child or the father hit the children, it's just a kind of a small beating with a small whip from the coconut leaf. So it's a kind of reprimand. So if it is beyond that, it's a severe beating, it will be called severe torture. So in ordinary term, tyrannicum, it can be like a mother hit a child, or a teacher hit a pupil, or the monk teacher who taught a student and hit. So I was hit by my professor. So it was referred to as well as tyrannicum, as torture, but in the intention to improve or to correct a person. So that's all I can tell.
All this semantic excursion is very interesting, but we are a court and interested in facts. So may I suggest, if it is unclear, if language is unclear, and we are only interested in what happened at S21, not so much what happens in Cambodian families at the moment. Counsel, why don't you, if it's unclear, what actions have actually been taken when the word torture was used, ask. Then we get the facts, which we will then evaluate.
Let me move on, Mr. Witness, and follow up what the prosecution has asked you in relation to interrogation methods. And as opposed to the prosecution, I will not use the English word in my questions, but I will use the original Khmer word, just to be very clear. Let me first refer you to what you said to the investigating judges, E3/454, English ERN 00147-603, Khmer 001466660, French 00149924. You literally said the instructions were not to rely heavily on Te Arunakam and be patient. Almost the exact same thing you said during this trial, the 9th of April 2012 at 9:18 in the morning. You said the interrogation and Te Arunakam were the last resort. What we actually wanted was their confession. Te Arunakam was the last measure. Was that the case, Mr. Witness? Not to rely too heavily on Te Arunakam, and that was the last resort?
Mr. President, that was my opinion after I had experience at M13. Pupali was recorded accordingly that torture would be the last resort. And when I testified in 2012, I also made a mention about the fact that torture should be the last resort.
Is it also correct that, as you said, with the exception of Koitun and maybe in Sambat, you yourself never participated in any interrogation, nor observed with your own eyes any interrogation, correct?
Thank you, Mr. President. I implore you, Council, not to connect Yum Sambat and Koi Chuan cases together. They underwent different experiences. Koi Chuan was personally interrogated by me. I had to prepare myself before the interrogation, and I need not to speak about this again. I would like to tell the fellow Cambodians that I myself interrogated Koi Chuan, and torture was not used. And no one used the term contemptible or to refer to Koi Chuan until the day that party decided to take Koi Chuan out for smashing. For Yum Sambat, I asked another interrogator to interrogate. I asked her to interrogate, and the recording was made at the time that Yum Sambat threw the grenade against the wall of the palace, and there were stains. There was this small destruction at that location. I told the court already about the case. Later on, the torture was inevitable against Yum Sambat.
Mr. Witness, forget Koitun, forget Yin Sambat. Is it correct that you never participated yourself in any interrogation, and you never witnessed with your own eyes what happened during interrogation? Is that correct?
Let me make a clarification. Since the time I was chief of S21, I had never tortured or interrogated anyone. Not at all.
Now let me follow up on this by reading something you said in E3/5771. English ERN 0018550 till 01, Khmer 001854992, French 001855509. As for the use of Tearunakam, the situation was the following. For simple combatants, Hor controlled everything and could order Tearunakam. For important prisoners, such as Ya, Son Sen gave me his orders on the use of Tearunakam. Is that correct? Do you remember saying this?
Mr. President, I have said this from time to time. I recalled well about the interrogation of Ya Koi Thuon and Tum. Brother Sun Sen intervened in the interrogations of those individuals by phone.
And my final question before the break, Mr. President. Mr. Witness, would it be fair to say that only in the specific situations when interrogators reported on what kinds of methods were used, that you would know what had happened during the interrogation?
That is true. I was so busy with enemies' documents. I called them enemies' documents because they were confessions. Practically, I do not know what was happening. The party lines was clear on interrogation and torture. I did had the experience and follow the party lines. President, it is now time for break. The chamber will take a short break from now until 10:30. Court officer, please assist the witness in the break time in the waiting room, and please invite him back into the courtroom at 10:30. The court is now in recess.